Hi everybody, Joel Silverman here from Silverman Law Office, coming to you today with our frequently asked questions. This FAQ is about probate and the probate process. So the first FAQ is, what is probate? Probate's the legal process by which, when a person dies, that a personal representative is appointed in the court to handle the transfer of their assets as that individual either directed in their will, or if they didn't have a will, then it goes as per state law. And the process in Montana, luckily, is very simple. We do everything, or most everything, just by court filings. We never actually have to have a hearing. It's one advantage to probate in Montana. FAQ number 2, what assets are included in probate? The only assets included in probate, and this is going to sound legalese, but they're probatable assets. And what do I mean by probatable assets? Those are the assets which are required to have a signature to transfer the assets from one person to another. For example, real estate. Real estate, somebody has to sign a deed. Well, if you've already passed away, you can no longer sign a deed to whoever you want the property to go to. Therefore, we have to get a personal representative appointed in the probate to be the person declared by the court to sign the deed to transfer the property as you directed in your will. FAQ number 3, what assets are not included in probate? Well, that can be very broad. Number 1, we always look at what we call the other category of your assets. Assets that are not included in probate are usually those assets, for the vast majority of us, that are owned as joint tenants with rights of survivorship, say for your spouse, or you can even do that with children, or that you have a beneficiary designation on. And luckily in Montana, we can even do that with real property, and we can do a transfer on death deed, where when you pass away, if you were to do a transfer on death deed to your children, all your children would have to do is provide the death certificate to the clerk and recorder's office, and the property automatically transfers to your children in ownership. FAQ number 4, what are the responsibilities of an attorney during the probate process? All an attorney is doing during the probate process is shepherding through your desires through the court process. They file the original paperwork with the court so that they can open the probate and get the what we call letters of appointment to the personal representative, which is the court's granting of authority for the personal representative to do all the things that you directed in your will. And then at the end, the personal representative and attorney provide an accounting to all the beneficiaries, and they move to close the estate once all the assets have been transferred. So as you can see, an attorney's job is just to shepherd the family through the process. FAQ number 5, how are estate tax debts paid? Well, first of all, almost no one is subject to the estate tax right now. The current exemption is now $13 million per person. So it's very few people that have to pay this debt, but it can sometimes be very large, because once you get above the exemption amount, the tax rate is at 39.5%. And at the end of 2025, Congress is set to roll that back, so it's going to be somewhere around 7 million. So as we've seen inflation impact us, there are more and more people getting hit with the estate tax. However, because it's such a small percentage of the population, most of us don't have to worry about it, and the estate tax is paid through the estate to the IRS, and everybody moves on, unless an estate tax audit happens, which those are rare. FAQ number 5, when is a probate required or not required? We only have to open a probate if you have probatable assets. A probate is required when, for example, you have real estate that you did not either have a joint beneficiary designation on the deed or a transfer on death deed filed with the clerk and recorder's office. If that's the case, then we have to submit your will to the court to get the personal representative the powers that are required so that they can then sign any personal representative deed to transfer the property where you have it designated. It's not required if all of your assets are owned in the form of either joint tenancy or you have beneficiary deeds on all of your assets. And last but not least, you could also have a trust that owns all your assets, and then everything passes through the trust as you've directed. However, what we see a lot of mistakes on is when you use a trust and you don't fund the trust, meaning you don't transfer all your assets into the trust, then we have to do a probate to move your assets into the trust. Thank you for joining us today, everybody. If you have any further questions or if any of these FAQs sparked a little more interest for you, don't hesitate to give our office a call and book a consultation with any one of our fantastic attorneys. Thank you and have a great day.